This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
You know, Dawson never gets old. I know I've said it once, but I could say it 100 times. Just the best. How are you on this Sunday morning?
I'm well. How are you, Mark?
Welcome to the Altar of Bart. I'm great. Sitting in New York City. And actually, as I'm sitting in New York City, I don't know whether it was arriving here or the issue itself, but the thing that's intrigued me this weekend, if you will, is the Sam Friedman trial that's going on here in New York City. You've been following it at all?
I'm following it well enough to know his name is Sam Bankman-Fried, which you've never really been able to get a fucking handle on. It's been about 5 years now that you've been screwing that up, but, you know, God bless.
I could say it's something. One of the reasons that it intrigues me is it's got a great issue that both lawyers and people who aren't in the law have been asking this week. And that is, how is it? You know, he took the stand. And when he first took the stand, I don't know if you have some of the headlines, but interestingly, people were perplexed. How is it that he's taking the stand in a jury trial, but when he takes the stand, there's no jury present? And that has befuddled, I think, some of the press and many people, both in and out of the legal community. Here we go. Sam Bankman-Fried. I got it that time.
There you go. When you're reading it.
Stumbles through cross-examination, and he wasn't even in front of the jury. And Leo, who I've been following on his trial reporting, does a decent job of reporting some of the facts. I may disagree with his handicapping of the trial because, as I've said once, I've said a million times, this isn't Sports Center, and what you may be handicapping for a game is not the same as a trial because you don't know what the lawyer's strategy is. But what happened here is there was pretrial skirmishing over whether or not the defense and what the defense could provide. Now, to a lot of people, this is absolutely provides or provokes wonder. What do you mean what you can provide or what you can testify to or what you can bring in as evidence? But the judge, as the gatekeeper, will oftentimes, and in this case, it's been constant, be asked by the prosecution to limit what the defense can present. So in this case, leading up to him taking the stand, the government had successfully excluded a number of witnesses that the defense wanted to call to show various things, to negate various elements of the prosecution's case. So once that happened, then the defense indicated that they may want to call, this is before he took the stand, the defendant himself, the accused, and the government, as the government loves to do, then wanted to get a dry run, if you so to speak.
Sure.
And what I mean by a dry run, Gary, is put him on the stand and get one crack at cross-examination of him, and then try to convince the judge to prevent him from testifying to large swaths of what he wanted to. That bug you at all?
It does. And that's not something that I'm really familiar with. That's not something that I was aware is common practice. Is that something that happens often? Is that commonly allowed, allowing the defendant to testify without the jury present and then the judge decides if he's allowed to testify? That does not seem kosher to me.
Well, this happens. I don't believe that it's common. I believe that it's more a creature of federal court than state courts. I also think, frankly, that it's an interference with a constitutional right, an absolute right to testify. Remember, we've talked about this before. The one or two areas where a lawyer strategically or tactically cannot overrule his client, the most first and foremost is the right to testify. A client's got an absolute right to take the stand. For the government to convince a judge to have a dry run, to me, it seems to be a fundamental assault on a constitutional, the most important constitutional right to a fair trial. But they were successful, and not only successful kind of circumscribing witnesses to corroborate his testimony preemptively, but also to circumscribe what he could testify to. Basically, his advice of counsel defense, when the judge has jumped in on cross-examination to anytime there's been a cross-examination of previous government witnesses to try to elicit the fact that there were lawyers in the mix, that there were financial consultants in the mix, that he wasn't the one, he being freed, wasn't the one making the ultimate decision. Or maybe making the ultimate decision, but filtered through the lens of advice of counsel. All of that has been circumscribed. And one of the things that I probably have taken the most issue with in the reporting on this case is the reporting on this case keeps talking about the defense as being befuddled, the defense is being muddled, I think is a term. There's been a hammering of the defense, and always couched in the mountain of evidence. I always love that, the mountain of the evidence that the government brings, not talking about the fact that the government has been prodding the judge repeatedly to interfere and circumscribe and get in the way of the presentation of a defense in this case. And this is probably the ultimate culmination of that, where you're forcing the defendant to take the stand to give the prosecutors a preview. Can you imagine if you made the motion in front of the judge, I want to put on the stand every single one of the prosecution witnesses outside the presence of the jury because I have I've got a problem with what they propose to testify to. You would get slapped down so hard. I mean, you'd be laughed out of court if you made that motion. And you know what the judge would say? The judge would say inevitably, oh, Mr. Gerges, you can cure that by making an appropriate objection as to irrelevance or outside the scope, or we can do it through motions in limine. Motions in limine are motions that would circumscribe what evidence comes in. Well, if you can do that for the government's case, who has the burden, why can't you do the exact same thing when the defendant takes the stand? It's infuriating in a way if you're on the defense side, and it should probably irk you if you're somebody who's interested in the fair administration of justice. Remember, the government will proudly tell you that they get in the federal system somewhere in the high 90s of a conviction rate, both combination of pleas and jury trials. And I would venture to say that the conviction rate at trial in federal criminal defense trials, mind you, which is a vanishing breed, is probably well in excess of 90%.
And how does this work where, you've got this defendant testifying without the jury present? Presumably they will in the future then bring the jury in and he will testify again, assuming it all goes correctly. Is the government allowed to then, take information from that first run and use it for objections or to contradict things that he may say when he is asked similar questions the second time with the jury present? I mean, it seems ridiculous.
It's exactly right. And it violates, I think, your right against self-incrimination, number one, and your right to testify. So it's like a twofer, both the fifth and the sixth, because inevitably the government is going to complain if the accused, when he's taking the stand, tries to testify to something that the government feels they had already successfully excluded. Then the judge, and inevitably the government will go, well, Your Honor, this violates the MIL. Well, the jury's going to hear that. The jury's going to know that something else is going on. If the judge sustains it, then they're going to say to themselves, oh, here he is now not obeying what the judge told him. I mean, it is so fraught with
And as defense counsel, you're going to inevitably go back and go, okay, well, let's look at this day. Let's look at what was said. Let's look at how we can present it differently. And if you present it even with a slight tinge of a different spin on what the answer to the question was, I would presume that the government's going to stand up and go, no. That's not what you said the first time. You can't do it like that. So it's like a dry run, but then you can't use it to improve upon.
Well, you not only can't use it to improve it upon, but it becomes a bludgeon against you once you take the stand. That's why I just think it should be prohibited. I think some appellate court at some point needs to step in and say, no, this is not how you do it. This is an infringement on your constitutional rights, both Fifth and Sixth. You want to exclude stuff. You want to say, no, he can't rely on advice of counsel. There's other options. Number one, do it in real time when have the government object and just say this exceeds the scope. Or more importantly, let the defendant testify. And by the way, cure it with a jury instruction. Tell the jury if you believe, and every judge will tell you, oh, I can do this, or I can do a pinpoint instruction, or I can do an instruction. Let the jury instruction cure whatever irrelevance you think the testimony might have, as opposed to jumping in the middle and trying to preemptively restrict it. Let me give you another example of why this is so absurd. If you, as a defense lawyer, put your client on the stand and you think that your client insists he's going to testify, number one, over your objections and to something that's at odds with what he's previously testified to. So I don't want to say it's perjurious. I'm just going to say, as a defense lawyer, you've talked to your client, that the client has told you something. He's been wedded to that. Now he's going to get on the stand and testify to something else. Well, the law is specifically that as a defense counsel, your ethical obligation is not to tell him he can't testify, although you can advise him to that, but to allow him to testify in a narrative form. He can get on the stand and he can tell it in a narrative form. You go through jump over certain hoops. Well, if that is the case, then what the heck are you doing here when you're trying to prescribe it in advance? Why does the court get in the middle of that sacred, sacrosanct idea? And by the way, it's not like people are just getting acquitted in droves by taking the stand in a case. As I mentioned before, the number of convictions in trial is minuscule as a proportion of the total conviction rate, meaning the number of times that you have a trial in federal criminal actions is a very small percentage. Then out of that universe of data, the number of times that a defendant takes the stand in a federal criminal case is even a smaller percentage there. So we are effectively, and every time I hear judicial conferences or talks about the vanishing jury trial in federal court, you wonder why. This is one of the reasons why. Talk about a frustration in order to a solution in search of a problem. This has to be it.
Yeah, that just seems absolutely ridiculous. That's hard to really wrap your head around.
Jewelry is having a big moment right now, and with hundreds of products popping up in your feed every day, it can be hard to find a brand you trust. Alex and Ani has been creating meaningful jewelry for over 20 years, designing pieces that connect you with all of life's important moments. With an emphasis on value, there's truly something for everyone. You might be most familiar with their signature charm bangle. This bracelet literally created the category of meaningful jewelry and had you stacking charms from your wrist to your elbow. This piece is an icon for a reason. Completely size inclusive, each bracelet is adorned with a symbol designed to tell your story and express your unique style. Beyond the bangle, you'll find stylish, affordable jewelry for every occasion, from classic pieces to bold statement looks. Don't know where to start? Alex and Ani makes it easy to unpack the trends you're after and sprinkle in your personality too. Each piece comes with a personalized message and meaning, truly making it the perfect gift. You can take comfort in knowing that you're shopping with a socially conscious brand as well. To date, Alex and Ani has donated over $60 million to nonprofits worldwide, connecting fashion and philanthropy in an easy, fun, affordable way. Visit alexandani.com right now to discover the confidence that comes with a perfectly accessorized piece of jewelry. Right now, Alex and Ani is offering our audience 20% off with code MIDAS at checkout. Again, head to alexandani.com. That's alexandani.com and use code MIDAS at checkout for 20% off your order.
Now, and I'll tell you, who I've been following on this trial, who is fascinating to me, is Martin Shkreli. You have his latest tweet, Martin, and for those who don't remember, I think has a special interest in this case. Full disclosure, he was defended at trial and was acquitted of, I think, 5 of 8 counts of trial, defended by none other than Ben Brofman and assisted ably by Mark Agnifilo and Teddy Garrigus.
Yes.
And Martin is now laying odds here.
I mean, this is hilarious.
Martin has plugged into exactly the way the press has been covering this, as if we're on ESPN Sports Center, right, Gary?
Yeah, absolutely. And for those who may not recognize the name off the top of your head, this is the gentleman who got in some hot water for raising the price of a drug by several 100%. Famously bought the one of one Wu-Tang album and was just a kind of an internet playboy for a moment, and eventually had to face the music and has come out on the other side of it, and now he's on X laying odds here. The outcome, he has it 5-1 guilty on any count, 20-1 guilty
right,
on
this
all
is
counts.
him handicapping the Freed trial, which
Correct.
He's been watching in real time and tweeting about, and has some pretty amazing insights for somebody who's been through it and understands it to some degree.
Yeah, absolutely. He's got it 20-1 guilty on all counts, 50-1 mistrial on all counts, a duration of 2-1 for the same day jury return, 3-1 for an Allen charge read, and 10-1 jury takes more than 1 week to return the verdict. I like the prop bets. 1,000-1 Sam or family is restrained by bailiff. That one. That one seems more like 10,000-1 if I take a close look at Sam and his family. 5-1 prosecutor victory lap lasts more than 5 minutes. That one I might take.
I'm going to tell you right now, if you could bet prosecutor victory lap lasts more than 5 minutes, that I would bet the house on that.
Too.
Let me give you some other. Cross-examination. Judge Kaplan admonishes Sam in defense more than 10 times during entire cross. I think that's already happened. So you would have made the even money there.
Yeah.
Then the other ones, I will tell you, mistrial on all counts, 50-1. I would not take that bet at all. You'd have to give me 1,000-1, maybe 10,000-1 that there's a mistrial on all counts. Because that would have to be a hung jury, again, across the board.
Yeah, absolutely. But this
because
is funny.
The judge is not going to grant it.
Yeah,
I mean, the judge hung jury is not going to grant it.
No, I agree with you completely. But 5-1 on a victory lap over 5 minutes. That seems like good money to me. I'll take that is easy money.
Yeah. Easy money. I would say if Martin was taking those bets and it was legal, that would be something you would go all in on, right?
Absolutely. And we're going to keep an eye on this trial for sure, because it's nothing if not interesting. It's, there have been some wild developments in this one.
Yeah, there sure has. Where next week, we talked about last week, we had Grubman on, who was the lawyer for the Chesbro or Cheesebro. Mangle his name as well.
Chesbro, yeah. He was that gentleman was Grubman was surprisingly compelling. He was really interesting and a nice guy, and I thought he was. I think we recorded with him for a lot longer than I think we expected to. He was very, very good.
Well, it was and it's fascinating. I believe they've got the fourth. Jenna Ellis pled. Last week when we recorded that, Powell and Chesbro had pled. Mind you, they had pled because they were on the eve of trial. And as I always invoke my father, it's amazing what happens to the accused when they see the whites of the jurors' eyes. And that happened. it was a little surprising that Jenna Ellis and is it Sam Hall? What was the name of the other lawyer? So you now have, I believe, 4 lawyers who have pled down there in Georgia, which is astonishing in a way that all 4, the 2, I think, because they were offered such sweetheart deals, Sidney Powell with a series of misdemeanors and Chesbro seemingly able to keep his law license. I can understand that. The other 2, Jenna Ellis included, I thought were a little surprising because I don't know that they had the pressure at that point, but maybe, there's an old adage, at least in federal court, the first one in the door gets the best deal. So far, that's been the case. The misdemeanors were given to Sidney. But then, as Grubman explained, the Chesbro got a non-RICO count and basically under the First Offender Act in Georgia, which has some great ameliorative consequences if you get through it without committing another offense.
Yeah, they say that the punishments are always the easiest for those who plead early, and so far it seems like that's kind of, to a certain extent, fallen true for everyone who's pled. You sort of start to wonder when the first person who's going to plead, who's going to see actual consequences is what I was going to say, but that's not to say that these people haven't had consequences, but significant consequences, I suppose, is more what I meant and should have said.
I also wonder what's going to happen. I'm fascinated by Rudy Giuliani's case.
Yes.
For a number of reasons. And he's kind of left out there on an island right now as one of the remaining lawyers who has not pled. He's also got real problems getting counsel out there, and he's the kind of meteor. I wouldn't call him meteor, but his fall, which has been kind of a death spiral, has been astonishing for somebody who was kind of America's mayor. Before that, poster child for federal prosecutors, kind of the head of the crown jewel of the Department of Justice, the Southern District. It's just been quite something to see.
Yes, it has. All right. I think we're going to wrap it up there. We will keep an eye on all of these cases and we will update you all next week. Thank you, Mark, so much for your time on a Sunday morning. We appreciate it as always. Enjoy your time in New York and safe travels as you come back to us in LA. We will look forward to seeing you back in LA for next week's episode.
Thanks, Gary. Have a great Sunday.
You as well. Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.